Hello, my name is Professor Marius van Staden from the Wits School of Law, and I would like to discuss with you the labour law shake-ups that are being proposed by NEDLAC. South Africa's labour laws are about to get their biggest overhaul in decades. After 2.5 years of negotiations at NEDLAC, government, business and labour unions have proposed sweeping changes that could reshape how we work. But here's the catch. They couldn't agree on most of it. So what's actually on the table? Let's break down the good, the bad, and the ugly of these proposed amendments. First, the good news. And there's quite a bit of small businesses that would breathe a sigh of relief. The biggest win? The new rules recognize that a corner cafe can't be expected to run the same complex disciplinary procedures as a multinational corporation. So the proposed code of good practice explicitly states that small businesses cannot be expected to engage in time-consuming investigations while keeping their doors open. This is huge. It acknowledges the reality that most small employers don't have HR departments staffed with labor experts. There's also a probationary period game changer. New employees won't have full unfair dismissal protection during their first 3 months, or longer if there's a reasonable probation period in their contract. This could make employers more willing to take chances on inexperienced workers. Plus, we're getting efficiency improvements at the CCMA. New rules will help speed up dispute resolution and reduce the backlog that's been plaguing the system for years. There's also a potential game-changing expansion of who counts as an employee. The proposed Schedule 11 would extend basic labor rights to gig workers, freelancers, and contractors who currently fall through the cracks. Think Uber drivers, food delivery workers, or freelancers working regularly for the same company. Under the new definition, if you work personally for someone and they control how you do your job, you are presumed to be an employee with the right to organize, bargain, collectively, and even strike. This could bring millions of South Africans into the formal labor relations system for the first time. However, there's a big catch. Business has rejected this expansion entirely, so like many other reforms, it may never see the light of day. But now for the bad. And it's particularly rough for workers across the board. Let's start with the massive stripping away of unfair labor practice protections. Government wants to delete key worker protections entirely. Disputes about unfair promotions, demotions, training opportunities, and employee benefits? Gone, unless you can prove that it's unfair discrimination. If your boss unfairly denies you a promotion or training opportunity, you'll have nowhere to turn. Labor unions call this an erosion of workers' rights. Then there's the massive two-tier system for high earners proposed amendment. If you make more than 1.8 million rands per year, or about 150,000 rands per month, you're losing major rights. No reinstatement if you're unfairly dismissed, just compensation, and even that's capped. I don't particularly feel too bad for this group of workers. And those probationary protections we mentioned, they cut both ways. While they might encourage hiring, they also mean new employees, often the most vulnerable workers, have almost no protection during their first months on the job. And here is where it gets really ugly, and I mean really ugly. Despite years of negotiations, the social partners are at war over these changes. Labour unions have opposed most of the key reforms, calling them attacks on worker rights. Organised labour specifically fought against the unfair labour practice cuts, arguing there's no justifiable reason to remove these protections. They lost their battle with government and business, but their opposition means these laws may never be implemented. Even worse, critical definitions are missing. What exactly constitutes a small business? The amendments don't say. This creates a massive loophole where an employer might claim small business status to avoid proper procedure. The inequality aspect is deeply troubling. We are creating a system where your workplace rights literally depend on your paycheck. High earners get fewer protection. Middle earners lose unfair labor practice rights, while only the lowest earners keep full protection. It is a fragmented mess. So where does this leave us? These amendments represent government and business trying to strip away workers' protection in the name of job creation. But organised labour is fighting back hard. Without consensus, these changes may never become law. And it should be noted that these amendments have generated the same momentum as previous successful reforms because the divisions are perhaps too deep. For now, South African workers face an uncertain future. Will these cuts to labour protection actually create jobs, or will they just make workplaces less fair? The battle is far from over.